So when are we going to get a ruling from the federal judge in the Southern District of Illinois? Again, no telling. But some of the questions and the answers that the judge drew out of the plaintiffs and defendants in the case in East St. Louis were pretty interesting. And one other kind of anecdote I want to share from yesterday's hearing was what the judge brought up multiple times when asking questions of the state who was defending the gun ban. And again, the arguments were that the plaintiffs say you can't ban guns that are in common use, saying that AR-15s and semi-automatic guns are in common use and you can't ban them, per recent precedent from the U.S. Supreme Court in the Bruin decision. The state came back and said, hey, it's clever marketing. People aren't going to be necessarily directly impacted by this for criminal penalties. Focus more just on the gun industry. It's where it has the most bite. However, individuals who are found with certain types of weapons could face criminal penalties up to a Class 3 felony, something that even the judge yesterday said seems pretty steep, because you get charged with a Class 3 felony, you lose a whole bunch of rights. You lose the right to vote. You lose the right until you serve your sentence in Illinois. You lose the right to own guns. You lose a whole bunch of things, let alone all the fines and possible prison time you could face. So Judge McGlynn said that's pretty steep. And something else that McGlynn had during the back and forth with the state defendants was a couple of scenarios that really kind of focus in on the key arguments here of not just the guns, but also the features, like, barrel sheaths or pistol grips or collapsible stocks. So on the gun side, he said, here's a scenario. A wife's at home alone. 4 intruders start coming in. She calls her husband and says, what should I grab? The shotgun with 3 rounds, the handgun, or the AR-15 with a 30-round magazine? And McGlynn seemed to suggest that she should go for the 30-round magazine in the AR-15. And who makes that decision for her? He also gave another scenario talking about the features and says, here we go. You've got, a tall husband and a short wife, but one AR-15. Why can't they have a collapsible stock? It's necessary. He even discussed things like, certain pistol grips that are really beneficial for people with, various disabilities, be it, they have an amputation of some kind, or they have Parkinson's, or they're elderly, and having the pistol grip allows them to more accurately aim things. So it was interesting to hear the judge. He seemed to really know what he was arguing about. And that was a major takeaway from some of the plaintiffs afterwards. By the way, I did try to talk with the state's defendant attorneys. They declined to comment as they walked out of the courtroom yesterday, but I was able to talk with a couple of the plaintiffs groups that we've already heard a lot from, but they were in the courtroom taking part in this, and one of those is Thomas Magg, who was there answering questions of members of the media, and here's how some of that went down, again, outside of the federal courtroom in East St. Louis yesterday for the hearing on Illinois' gun ban and the challenge against it.
The questions seemed very fair, very balanced. Again, it's obvious that he had read the topic. He was obviously familiar with the subject matter. I think the hearing went very well. I think common use is very important. Obviously, the first step is whether the arms are prima facie protected under the plain text of the Second Amendment. Common use is very important. These arms are all in common use. AR-15s are in common use. M1 carbines, some of them prohibited by the Act, in common use. Over 15-round magazines. I can't think of a modern firearm that doesn't use it in excess of 15-round magazine. I think there were good questions from the judge. I mean, the judge had obviously noticed that the state had labeled a flare gun as a grenade launcher, which is a world of difference between a flare gun, which is a distress signal device, and a grenade launcher, which is designed to throw bombs a couple of hundred yards. And there's a world of difference between an anti-tank rifle or an artillery piece and a 50 caliber rifle. Historically, going back to the Revolution, firearms had bore diameters well in excess of 50 caliber. It's just another common cartridge in common use today in this country. Obviously, the elderly, those with physical infirmities, require different types of firearms than a strong 19-year-old bodybuilder. Yes, I do think that that's very important. For instance, my own mother-in-law has severe arthritis. She cannot handle most modern firearms. We had to find one that she could handle with her arthritis. The weak point in the defendant's arguments boils down to that they're arguing that the legislature is not bound by the Constitution. That's the exact opposite of how it really works. The Constitution controls what the legislature does. The legislature doesn't get to control what the Constitution does. Judge McGlynn had obviously read all the briefs. He was obviously familiar with the topic. I did not think much of the state's argument. The state's argument simply seemed to boil down to that the legislature can do what they want. They seem to ignore the Bruin case out of the Supreme Court. I'm optimistic that in the coming days or weeks, Judge McGlynn will enter the TRO that we've all requested.
So again, that's the Thomas Magg first attorney that brought the state-level case in Crawford County that was transferred to federal court and then lumped in with three other cases in federal court being heard yesterday in the federal court in East St. Louis. And you hear there some of the arguments. That was something the state said is, hey, we're self-governed. People voted for the legislature, and this is the will of the people, they said. And they made that argument throughout their arguments, but again, Mag saying it's not how it works. It's the other way around. It's not the state telling the Constitution what to do. It's the Constitution telling the state what it can't do, pointing to that Second Amendment argument. Todd Vandermeide, somebody we've talked with all throughout this. He's got the YouTube channel Freedom Steel. You can check him out as well. He's very detailed, very specific, knows the industry, knows the firearms in and out. And he essentially said it's clear that the judge as well knows firearms inside and out. And Todd Vandermeide, everybody. Also known as Gun Santa, apparently. Yeah. So here's Todd yesterday.
I think it went well. I think that unlike what we've seen in a couple of the other cases, you have a judge who understands firearms. I think his questions showed that he understands the nuances of this, making a question about a flash hider. And I think he clearly went through the documents that we provided in our illustrations where we showed that, you can add a flash hider to a 1022. A rifle, we believe, is banned under this act. For us, this means that we reset things back to January 9th. This gives all the individuals the ability to go back to acquiring firearms that maybe they didn't have the money back then to acquire, that they've been saving up and now they want to acquire. A gift for somebody like a son or a daughter that they were planning on buying something for. Or, just as you've seen, we got turkey season going on. You had I-4 issue a press release, and the Illinois Department of Natural Resources is telling hunters they cannot take some of these shotguns out onto public land to hunt with. You've got people who carry Glock 17s. They cannot carry that firearm with a 17-round magazine out in public today. It's even questionable whether or not you can have that magazine loaded inside your car as you're driving down the road. If you have a Glock 17, you cannot walk into any restaurant. You cannot walk into any gas station. You cannot walk into any other private property that's available to the public. And I think that the way they've written the readily convertible language within the the magazine component, I think they have actually said that my Glock 19 with a 15-round magazine, because the base plate is removable, is an illegal magazine for me to carry out in public. It's not a 15-round ban. I contend it's more of a 5-round ban. We've seen reductions in 60% or more in some stores as far as what their availability to sell, because it's not just the firearms. It's the components, it's magazines, it's stocks, it's parts. This bill, this law does not allow me to repair a firearm if I don't already have the parts in my house. I cannot buy a detent spring. I cannot buy a barrel to replace a shot-out barrel, or any of those other components within this. They refuse to acknowledge how far and broad their ban goes. Because I'd even contend that based under Section 24.1.10 of the magazine ban, the 870 shotgun is illegal for sale in the state of Illinois under their magazine ban.
So again, Todd Vandermeide, Thomas Mag, outside of the federal courthouse in East St. Louis after the hearing, very confident that Judge Stephen McGlynn will issue a preliminary injunction against the law. I want to hear from you what your prediction is. We'll have time after the break just for a couple of them, so get your calls in at 217-629-7970. And I hope to line up a few of your calls. You can call in at 217-629-7970. Got just literally 2 minutes here for you to sound off. But where do you think this is going to go? The case in Southern Illinois, Southern District of Illinois Federal Courts. You had Judge Stephen McGlynn, who asked a variety of questions of both sides, but ending the hearing essentially saying that from where he sits, he doesn't just look at the gun, he looks at what's going on with these people who are committing bad acts, and seems to share a sentiment a lot of people have had of, listen, it's not the gun that commits the crime, it's the individual who commits the crime. And by going after the gun and limiting that, you're limiting law-abiding citizens' Second Amendment rights to access firearms that they choose for themselves to defend themselves. While the state's arguing that there's a proliferation of these guns, and while that might be considered common, that's what they argue is leading to increased mass shootings. But people push back on that and say, listen, a lot of these mass shootings may be done with weapons that are legal under this particular weapons ban. And even McGlynn, during the hearing yesterday, he brought up the issue of bolt-action rifles, saying that a bolt-action rifle is legal under this, and the bolt-action rifle was used to assassinate a U.S. president with 3 shots under a minute in Dallas in 1963. And he said if Oswald would have stayed up there and continued firing on other people, he could have done a lot of damage with being able to fire somewhat rapidly. But regardless, the judge took it under advisement. The prediction from the plaintiffs is they're going to get a preliminary injunction blocking this law from being enforced while it goes up the chain all the way to the U.S. Supreme Court. So what happens, we'll keep it here and update you. And I want to give a shout out to everybody who's been along for this ride. It's been a long ride. It's been a busy ride. I appreciate all of the love and the kudos. And we had peak numbers here watching live. It's pretty awesome.
From the Fly SPI Studios, take the